At the time of closing our organization also, it has to be closed as per the concept of the law, and we cannot take our own decisions to close our business activities. Insolvency is nothing but here when the company's debts are more when compared to source of income. If the board of directors fails to convince the creditors, then the creditors will say that when the company has to be closed. Warm welcome to all my dear students for BCom second semester company law subject unit 5 liquidation of companies. I'm Rajesh L.R., lecturer in Department of Commerce and Management, Vidhyaashram First Grade College, Temple of Excellence, MYSURU. In today's unit, we are going to discuss about the liquidation of companies. In this one, we should know that one, what do you mean by liquidation? Why the liquidation is going to take place? Liquidation is nothing but we are going to close all our business activities. Means we are closing all our business activities for totally. This liquidation process may take place for certain reasons. It may be like we have made a contract or we have started the company with intention for only for a couple of years. After the completion of the tenure of the period, we have to compulsorily close our business because we started only for particular project. Like this, certain things are there we were to learn in this unit. In the first part here, in the agenda, we are going, as we said that when we are going to understand about the liquidation of companies, meaning, modes of liquidation, consequences means why the liquidation has taken place in the market, and appointment of official person. We have to appoint a separate person who should not be belonging to the management. He should be separately appointed either by the court or by the government to liquidate the company. And what are his duties and responsibilities are there at the time of making liquidation, and what he has to take care, and what is the benefit he is going to gain from the process, what he is going to do for the purpose of the company. Everything we are going to learn here. It is very interesting topic, and in this chapter you're going to gain the knowledge about why the liquidation will come into existence and why a company has to be closed down. Means you can take care yourself that one, and your financial purposes you can have the better control instead of leaving that one into liquidation. And from this chapter you're going to get 2 marks question as well as 10 marks questions where you can secure 12 marks to clear your examination purposes, right? The first topic here we are going to discuss about liquidation introduction. A company comes into being through a legal process. They're saying that when we are going to start a company that has been started through certain legal process, we have started that with certain legal process, and also comes to an end by law. Means at the time of closing our organization also, it has to be closed as per the concept of the law, and we cannot take our own decisions to close our business activities. Liquidation is a legal procedure. They are saying that when liquidation is a legal procedure where we have to know that when why the liquidation takes place. Liquidation means winding up, or it is called as owned up. Means we are going to close all the business activities of the organization. Comes to an end, all the business activities of the company will be stopped, and there will be no further transaction in the name of the company, and nobody should do any business activities after they approach for the liquidation. Before liquidation, if they have made any contract, that has to be completed, or else after the approaching for liquidation, if any company enters into contract, either the court or the company is not liable for any consequences which they are going to face in the future. a company when found necessary can be liquidated. They are saying that when a company can be closed on certain grounds, like for example, the company's debts are more than the income whatever is earning. Now the company is not in a position, even after selling all its assets, it is in not a position to clear all the debts, and they're not clearing the debts on a proper time. At that time, the company should be closed instead of continuing the business. So the people have to take care of that one. People means here the members of the organization have to take proper decisions before stepping into any projects or investments, which if they have the knowledge of doing such proposals, then they have to accept. If they doesn't have that one, first they have to collect in-depth information if we accept this project, whether it is going to positively successful for our company or not. Then if it is not successful, they have to face the liquidation. For that reason, all the members should be very much have to take care in the business activities. Definition as per Companies Act of 2013, we have here section 2, subclause 94A says that when winding up means here winding up under this act or liquidation under the Insolvency Bankruptcy Code 2016 as applicable. They're saying that when insolvency, if the company is under insolvency, means it has to be liquidated. Insolvency is nothing but here when the company's debts are more when compared to source of income. Like for example, the company's debts are 1,000 crores and the company's income is only 10 lakhs. In this situation, the company cannot be run here. For that reason, the company has to be liquidated. Or the saying that in bankruptcy, it is nothing but, for example, the company has borrowed a huge amount of funds and it is not a position to repay the funds after even it is going to clear the bank amount properly. Means the bank cannot collect the full amount given to the company. At that time, the company has to be liquidated. Modes of liquidation. What is this? Modes is nothing but here on what grounds the company may be closed and which are the types. Modes is nothing but we can understand the simple concept called types here. Means the first one here, compulsory winding up by the court. The court is going to make an order for the company. Your business activities are to be closed. The reasons we are going to discuss. And voluntary winding up, the company only takes certain decisions with the help of the creditors or with the help of the members, whether the business has to be continued or not. Then that go for the voluntary winding up. Members voluntary winding up. That is, as I said to you people, that one, they're going to have a last meeting, members meeting they're going to conduct. In that members meeting, all the members will take decision that one, the business activities are to be closed. Means the reason may be, there may be a conflict between the members or the decisions taken by the company for the growth and they are made in such a way that when there was a huge loss has been occurred or the proposal which they accepted was not perfect. Like there were plenty reasons are there why the company has to be closed here. Next, creditors voluntary winding up. Sometimes the creditors will approach the law and through the law they want to close the company because the creditors are not in a position receiving the money or the debt given to the company. When the company fails to make the payment to the creditors, then the creditors will approach the law. Through the law, the business has to be closed down. Voluntary winding up under the supervision of the court. They're saying that when the business activities will be closed with the supervision, means they're going to observe each and every activity of the company and based on that they're going to close the activities of the business here. First one we have a liquidation by court. Forced. The court makes pressure or sends a notice to close all the activities of the company because the creditors are no longer believe the firm can pay them back. Means the creditors have approached the courts stating that when we are not in a position that we are going to get back the amount whatever we are paid to the company, the firm cannot pay the money for us. For that reason, we are approaching you. The company has to be closed. Or else, at least if the company is closed now, we may receive certain amount. In future, we don't know that even I'm going to receive a single pie also from this company. For that reason, they'll take a decision that one, let us approach the court here. Through the court, let us make the firm to be closed here. Next one, voluntary liquidation of a company. A company can be wound up means liquidated voluntarily under the following circumstances. So which are the stages we have here and how the firm will be closed here, we are going to discuss here. First one, by ordinary resolution, means they are going to conduct a meeting. Normal meeting will be conducted. In that normal meeting, all the members who have participated in the meeting, they will take a decision that when the company should be closed with certain reason, where the duration of the company was fixed by the articles and the period has expired. Means the first concept what we have here under ordinary resolution means when we have started our business, in our articles, we have mentioned that clearly that the company will be existed only for number of years. Means here, example, we are going to have our business activities only for 4 years. As the 4 years is completed, the company has to be closed all its business activities. Next one, where the articles provide for winding up on the occurrence of any event and specified event has occurred. They're saying that when you made articles of association, and if you have not followed the articles of association properly, the event which you are involved, it is against to the articles, then they are going to close all the business activities. For example, misleading, fraudulent activities, and wrong information providing to the public, and collecting the amount for not giving returns. Means they are going to collect the amount from the public with an intention that will not to refund that amount. Like this, if they come to know the event which are going to take place may be a illegal concept, then the other members can take decision for voluntary wind up here. By a special resolution, there it was ordinary, now it is special resolution they are going to make. When resolution has passed by the members in all other cases for voluntary up, it must be notified to the public by advertisement in the official gazette or in newspaper. They are saying that when all the members of the company decide to close the business activities, as soon as a resolution has been passed, the same information has to be made to the general public through the newspaper by giving an advertisement that X company will be closed from such and such date. And even it has to be published in the gazette, means an official document will be sent for companies as magazines, where in the gazette official almost all the information will be there about related to the company's activities of entire Bangalore, or it may be entire Mysuru, or it may be entire state. Like this, what are the things happening in the market, these information will be published over there. And it is an official document where they are going to submit for even for ROC and for other concepts also. Next, we have here types of voluntary liquidation. Under voluntary liquidation, we have different types. The first type we have here, members voluntary, and the second one we have creditors voluntary. Means here, they are saying that when members voluntary wind up means the members are going to take decision to close all the business activities because the company's position is not in a good, and the company's performance is not up to the expected thing because some of the members are involved in the fraudulent activities. For that reason, we want to close the business activities. Or creditors may take a decision that whatever the amount we have paid for this company, we may not recover So for that reason, let us have a meeting, and such meeting we're going to call it as class meeting. Under class meeting, a creditors will call for a meeting, and the company's board of directors and all the creditors will conduct a meeting. In the meeting, they discuss about all the things, whatever it is happening. Based on that, if the board of directors gives the assurance that there will be no problem for your debt amount provided, then they will take a firm decision not to close. If the board of directors fails to convince the creditors, then the creditors will say that the company has to be closed. Either we are approaching you directly here to close all your business activities and settle the amount, or we approach the court, then the court will take a decision for liquidating the company. Who is a liquidator? See, for liquidation process, a person is required. A person is required to take care of the liquidation process. What is this liquidation process? Means, as the company is a legal entity, the company will have own certain assets in the company's name. The company's assets are to be sold in the market. Whatever the amount is generated or received from the sale or transfer of such assets, that amount and the cash in hand or cash at bank amount, whatever it is there, all the things put together, what is the total amount is available for making certain payments for the debt people who are there, like preferential creditors, secured creditors, unsecured creditors, and debenture holders, or the members who have contributed the amount here. To do all this process, we require a person who is not related to the company. Means that saying clearly that the person whom we are going to appoint, he should not be a member of the company, or he should not be a creditor of the company, or he should not be a part of the company at all, where he will be appointed either through the court or to the government here. Liquidation of a company, one or more persons are required to be appointed specially. They're saying that in some cases, we should have at least more than one person to take care of the liquidation process for conducting the liquidation or winding up proceedings of the company. Such a person are called liquidator. He is required to realize the assets. As I said that realize means selling the assets in the market, and discharge the liabilities. Discharge means making payment for the persons who have given the debts to the company and who have invested in the company here. And distribution the surplus, if any, among the shareholders. If there is excess amount after making all the debt amount has been cleared, if anything remains, that has to be distributed to the shareholders of the company. This is a concept what we have under liquidator, and it is a 2 marks question where you have to write for the examinations. Who are contributors? Contributors are all the present and past members. They're saying that the people who have contributed for the company, either who are at present means who are the members of existing at the existing time, and the people who were there earlier. Both the members of the company are liable jointly contributing to the assets of the company amount with sufficient for payment of its debts. They're saying that they have contributed the amount in such a way that where it should be equal to clear the debts and the liabilities to meet the cost of liquidation. They're saying that whatever the amount are there, assets are there that are to be sold in the market, the amount whatever we are going to realize, that should be utilized for clearing the debts as well as for the cost of liquidation. For both, it has to be used. Adjust the rights of the contributors among themselves. They are saying that adjust the rights of the contributors means whatever the rights are there, the people who are members of the company, their rights are to be adjusted in such a way they should not feel in way that the liquidator has misused the funds. For that reason, the liquidator is going to discuss with all the members or the contributors about the status, and is going to learn why the company was closed and what are the certain reasons were there or the consequences were there, and how we have to settle the process of the company's assets as well as liabilities. Now, what are the functions of the liquidator? First, see, as I said that one, to realize the assets of the company means here the liquidator first has to collect each and every information from the company. What are the assets are there, like how many fixed assets are there, and current investments are there, non-current investments are there, and other current assets. Now, after collecting all the information about the assets, he has to sell all the assets in the market. Then the second duty of the liquidator will be to collect money due from the contributors. Like, for example, if the members are due to the company, collect the amount, the due, whatever it is there, from the present or the past members for the purpose of liquidation. And then the third step, to distribute the amount realized from the sale, means as per the section 329 of Companies Act 2013, they say that when whatever the amount you have received from the sale and the cash available with you, now based on the amount available, and we have certain procedure here that has to be followed as per the Companies Act. That it says that for whom we have to give the first payment, and the second and the third and the last for whom we have to give. As per the norms only, we have to make the payment here. In order to preference as per the rule, means preference means here for whom I have to pay first and then next and the next. Like, for example, always we have to make the payment for secured creditors. The first payment should be made for the secured creditors, and the second payment should be made here for liquidation expenses or legal expenses, whatever we have here. And the third we have to make for the liquidator's remuneration, and then we have to make for preferential creditors, then unsecured creditors, and then debentures or any other persons who are there. And later, if any surplus amount remains here, that has to be given to the shareholders. To maintain and submit the record of receipts and payments of cash to the members in case of voluntary winding up, and to the court in case of compulsory. They're saying that one, the next function of the liquidator will be whatever he has done, the activity or the activity which are taken place at the time of liquidation, he has to maintain a separate book or a statement recording all the receipts, whatever the amount received here. And next, here we have the payments. Payments means here whatever the amount has been used, for what purpose it was used, and when it was used, and why he has used such amount, and how he made decision to make the payments. Next, we have here liquidator's remuneration. So this is a very important topic. Liquidator means if they appoint me as a liquidator for the company, I have to receive certain amount of benefit. That is called remuneration. Now, a fixed amount paid to the liquidator means I'm going to say that one. If you are going to involve in this liquidation process, then we are going to pay you fixed amount, and certain lump sum amount will be paid to you for the entire process. Or if you don't agree for the fixed remuneration, then we are going to pay a certain percentage on assets realized by the liquidator, as well as an amount paid to the unsecured creditors. For example, if it is a percentage, means like if I sell all my assets excluding cash in and cash at bank, excluding cash in and cash at bank, the assets whichever I've sold in the market, on that they may pay 2%. And the amount whatever I'm going to pay for the unsecured creditors, they may pay me 3%. This is an example what I'm giving here. The percentage may be 2 and 3% commission for doing such activities. If you want on percentage basis, there's a process we have, or for the entire process of liquidation, we may pay you 1 lakh. We may pay you 1 lakh. Like this, they are going to have the concepts. Next one we have here, preferential creditors. As we were discussing liquidation process, I said that one, first it has to be paid for the secured creditors, then preferential creditors. See, preferential creditors who are those people? Now, all revenues, taxes, cesses, and rates due from the company to the central and state government. They're saying that when preferential creditors means here, whatever the company is due for the state government or central government, either in the form of duty, taxes, cess, whatever it is there, that amount has to be paid first. And next, any amount to the local authority like municipal corporation or any other at the date of closing the business, and payable within the 12 months next before that date. Having become due and payable within 12 months means they are saying that one they have made certain provisions to make the payment of duties here within 12 months. If they're not paid that one, like it may be a tax to the government, either it may be income tax or in the present scenario, the GST, whatever it is, if they're not paid that one, the duty of the liquidator to make the payment for such things. Next, all the wages and salary, including wages payable for the time. Time means if the company is a manufacturing company and if they are paying wages to the laborers on the basis of time or on the basis of piece wage system, time wage system and piece wage system, then the salary earned wholly or in part by way of commission. First, we have to make the payment to the government or local authorities, whatever it is there. And the second payment we have to make for all the employees or laborers of the organization where it is due. And next, the company due for a period not exceeding 4 months within the 12 months next before the relevant date, and any compensation payable to any workman under any provisions of the Chapter 5A. They're saying that one, if any incident was taken place and if the company has not paid the compensation, the incident which has taken place 4 months before the liquidation and which has to be paid within 12 months. So if any such cases are there, then they have to make the payment for the compensation. Or under the Industrial Dispute Act 1947, amount payable for one claiming does not exceed 20,000. They are saying that one, whatever the amount compensation they have to pay, the compensation amount at the time of liquidation should not exceed 20,000. Next, we have here the same concept in a different way. We have made here preferential creditors are those expenses of investigation. Means here, for the purpose of closing the business activities and to find out who are the creditors are there, secured creditors, preferential creditors and unsecured creditors, and even why the business is closed here. If any investigation has been made here and if expenses are incurred, make the payment of expenses first. And if any holiday remuneration are there for the members of the company, pay them first. And contribution under ESI concept, if the company has followed certain rules and regulations at the time of doing business activities, that is nothing but contributing the amount to the employee state insurance for the benefits of the employees. If any amount is due, make the payment immediately for such dues. Workmen Compensation Act, if the company has not paid any compensation amount to the employees for the accident which has occurred during official hours, for any employee, any damages has happened, then they have to pay the compensation amount. And then PF, Provident Fund, if there is any contribution of the employer as well as the employee's amount not paid to the Provident Fund, then make the payment for the Provident Fund, Pension Fund, Gratuity Fund. All these will come under preferential creditors. The next one we have here, unsecured creditors. The name itself says that one, the creditors are not secured. They rank below secured creditors when it comes to the receiving payment. They're saying that one, unsecured creditors will be coming under the secured creditors at the time of liquidation of a company. The benefit having a claim over a particular asset and can include suppliers, contractors, landlords, and customers. Here, the people who are given certain amount to the company here, and the company has not paid the amount to them, either it may be a rent, That is, amount payable to landlord means outstanding rent, or the amount not paid to the contractors for the work, whatever they have done, and the suppliers supplied the goods for the company. For all those people will come under the unsecured category. Next, liquidation process means how the company has to be liquidated and what are the steps are there. First, if directors decide to voluntarily liquidate a business due to inadequate cash flow, they're saying that one, the directors of the company, they decide that one, we don't have sufficient funds in the business organization. For such reasons, let us close our business activities voluntarily. And next one, the company or the court appoints an insolvency professional, IP. Insolvency professional means a person who is going to take care of the liquidation process, means is a person appointed for the purpose of taking all the liquidation activities. He is none other than official liquidator to take charge for the process. At this stage, the owners lose their powers and rights. The liquidator takes over. The members of the company will lose their all powers and rights. They have to surrender all their rights and powers to the official liquidator, and official liquidator will receiving all the rights and powers on. After that only he is going to start the liquidation process. If the directors or any of the member has not transferred the rights or the powers, then he cannot be called as a liquidator, or he cannot involve in the liquidation process at all, because he cannot take decisions. If the rights and the powers are not given, he cannot take decision to sell the asset in the market for certain price. For that reason, the first duty of the liquidator is to collect or get all the rights of the owners and even the powers, whatever they have, and the decision taken by the liquidator will be the final decision. Liquidation process. Next step, the liquidator dissolves the assets after assessing, means is going to dissolve the company after collecting all the information by transferring all the assets. Next, the liquidator determines all the payables and debts of the company. He is going to collect all the information of the company, how many liabilities are there and what is the total amount outstanding, and in that one, how many preferential creditors they have, secured creditors they have, and unsecured creditors, and then later on the members in details. Finally, the authorized liquidator distributes the funds among the claiming parties based on the standard order of priority. They're saying that the liquidator, after collecting all the information and selling all the assets in the market, whatever the funds has received, is going to make the payment on the priority order. As I said to people, the first amount will be given to the preferential creditors, then secured creditors, then unsecured creditors, and if anything surplus remains, that will be distributed to the shareholders of the company. The last one, the company ceases to exist, is taken off the register of companies, means they're going to say that one, the liquidator has to communicate the information to the ROC stating that one, the company's all the assets has been sold and payments have been made. From today onwards, the company does not exist. What are the rights and duties of the liquidator? Now, as I said that one, when an official person involves in the liquidation process, he has to gain all the powers and rights of the owners. Now, what will the rights of the liquidator? As I said, ost powers depending on the type of liquidation. He has to check that one, what type of liquidation process is taking place. Either it's a member voluntary winding up, or creditors voluntary winding up, or liquidation by court. Based on that, he has to take the decision. Their main responsibility is to convert any remaining assets or property of the company into cash. They're saying that when whatever the assets are there with the company, that has to be sold in the market and convert that one into cash for making the payment to the creditors possible. To assess all the debts and decide which should be repaid, and full in part, in some cases, claims can be rejected. They're saying that when the liquidator has to assess all the debts of the company, for which type of debts the full amount has to be paid, and for which type of assets a part amount can be settled, and which debts are to be rejected with the reasons he has to mention. Bring to an end an outstanding contracts or legal disputes. Means they are saying that when at the time of liquidation, the company, if it is under any disputes with any person outsider who has filed a case on the company, that has to be closed. That has to be closed before completion of all the liquidation process. And if the company has entered into any contract, the contract has to be cancelled before the liquidation process. Next one, seek valuation for company assets, maximize returns for creditor. They're saying that when after receiving the rights and powers from all the members of the company, the main duty of the liquidator is to value the company's property. Company's property is nothing but company's assets. All the fixed assets are to be valued properly, and he has to make in such a way that when where the assets has to get more value, then he can pay the amount without any hurdles or without any issues to the creditors. If the assets are sold in the market at very low price, then he has to face huge problem at the distribution of payment to the claims made by the creditors. Closely inspect the restoration of property that may have been sold at undervalue. Means they are saying that whether any assets are sold less than the book value, he has to judge that why it has happened, for what reason it has happened like that. Then he has to take a proper decision. Keep creditors informed, involved in the decision-making process where appropriate. They're saying that when the next right of the or duty of the liquidator will be, he has to communicate each and every information to the creditors, what it is happening and how much funds have been received and how the funds are distributed. And next, communicate how creditors claim for progressing, the reasons why the company failed, as well as details about the redistribution of assets. They're saying that when the liquidator's next duty is to convince all the creditors why the company is going to pay only lesser amount when they are paid huge amount for them. The liquidator has to give clear information to the creditors. This is the reason why the company has failed to pay the debt amount, whatever they have received. Now, we are going to check that one. We are going to sell the assets in the market. Whatever the amount is realized, such amount will be paid to you. Interview and report on the factors that led to the company's demise and liquidation. First, he has to collect all the information from the members and the investors, why the company is going to be liquidated, what was the main reason where it failed to reach the concepts, what was the main factor influenced for taking such decisions, and how it has reflected on the business activities. Now, dissolve the company. The last and final concept of the liquidator will be, the duty will be dissolving the company. Thank you, my dear students. In today's session, we have learned about what is liquidation and the process of liquidation, functions of liquidator, and even the types of liquidation. From this chapter or the unit, there will be compulsory 2 questions for the examination. Go through that one where you can succeed in your examination as well as in the upcoming your future life. If you take a right decision, then you never face such type of liquidation for your business. You're going to be a good and fine entrepreneur if you take a proper steps in your business activities. Thank you, my dear students.